Good afternoon, everyone. Richard Cullen is my name, and I'm the convener of the Tax Law Research Program here at Hong Kong University. And welcome to everybody. Many of you will be joining us again, and welcome to new people. We're very pleased today to have Dr. Professor Stefano Grilli from Milan, from University of Milan, and also a partner at Deloitte in Milan, who's actually here for the BRI forum on tax cooperation, which is being held in Hong Kong right at the moment. So we're very pleased he's made time available to speak to us. Professor Grilli is an adjunct professor of international tax at the University of Milan, a partner at Deloitte, as I mentioned. He served as a senior counsel to the Italian Ministry of Finance for the Italian presidency of the G7 in 2023 to 2025 and the G20 2020 to 2021 in relation to international tax matters, especially Pillar 1 and Pillar 2. And he's a member of the advisory board of the Belt and Road Initiative Tax Administration Cooperation Mechanism forum that's been going on here in Hong Kong, and an independent person of standing as per Article 9 of the Council Directive of the EU from 2017. That's enough from me, I think, but let me just say, as a reminder to everybody before we get started, there will be Q&A available, so if you have questions, you can enter those through Zoom, and we'll put as many of those to Professor Grilli as we can. The PowerPoint slides that will be used, we have those, and we'll be loading them on the website shortly so that you can access those after the event, and we'll also have a recording of the event for those of you who want to come back and listen to that. Enough from me. Welcome, Professor Grilli.
Thank you. Thank you, Professor Cullen. Thank you, Hong Kong University, for having me here. The topic of today is the global minimum tax. Obviously, given the magnitude of the subject matter, we are going to really scratch the surface of the topic. Global minimum tax, otherwise known as a Pillar 2, or global rules. Before delving into the details or trying to analyze a bit more in detail the global rules, I think it's worth understanding how they have been devised, because this is the first example of a legislative multilateralism. Because the OECD has been instructed by the G20 inclusive framework to draft a set of rules, here hence the global rules, in order to reduce BEPS, which is base erosion and profit shifting. It's otherwise called BEPS 2.0. The purpose of these rules is to provide the fact that all over the world, all the jurisdictions will tax corporate income at the rate not lower than 15%. The way the rules operate, it's pretty ingenious, with some devilish mechanism we'll see later on, which de facto brings the country, imposes to the country the application of a corporate income tax at 15% rate. And you are seeing countries like Singapore, like Bahamas, like Bermuda, like Barbados, like UAE, they all are rolling out QD entity, which is a type of corporate income tax at the level of 15%. This is because how in broad lines the rules operate. Conceptually, for those who are knowledgeable to the subject matter, it's a big CFC regime, which applies. It's basically like a US GILTI, but the GILTI applies at the world level. There is a US versus rest of the world. Here you have the UPE, the ultimate parent entity, versus the relevant jurisdiction in which the group operates. Another peculiarity of these rules are that they don't look at the specific subsidiary or permanent establishment of the group in the jurisdiction. They combine all the relevant entities, which under the language, the jargon of the modern rules, they're called constituent entities. So if a group have 3 subsidiaries and 2 permanent establishments in one jurisdiction, the income and the taxes of those 5 entities are combined together in order to assess whether the 15% is reached. Again, being a form of legislative multilateralism, the model rules are not law. As their name suggests, they are a draft of law provision that the member state of the inclusive framework, are invited to transpose into their domestic legislation. They are not obliged to adhere with the Pillar 2, and instead, and in fact, as we will see shortly, only a limited amount of countries have so far adopted the Pillar 2. But the OECD says you are not obliged to adopt Pillar 2, but if you do, you have to conform with these rules. Because if you do, the state, if you do not, the mechanics of this rule is such that your country, your companies, i.e. the companies and the permanent establishments located in your jurisdiction will be penalized by virtue of the mechanics of the law we'll see shortly. So basically, those are not compulsory rules. Member states of the inclusive framework are free to adopt. If they do decide to adopt, they have to adopt exactly in the way they've been devised. Because the purpose is to consider the world as one jurisdiction, where each and every real life state applies through its constitutional process the same rules. So obviously, the world is not one world, legally speaking, is divided in 180 plus jurisdictions. Each of them is a sovereign state, which may decide or may not decide to implement. If it does implement, it has to implement exactly along the lines suggested by the OECD. In Europe, we decided to implement the Pillar 2 through a directive, which is a legal instrument recognized by the European Union, which basically obliges the member state of the European Union to transpose into their domestic law the provision of the directive. The provision of the directive basically are a copy and paste of the model rules, although drafted differently, but it's just a matter of language. The content is exactly the same. Now, the first point is that being a legislative multilateral in exercise and not a real law, this triggers a lot of issues, also constitutional issues, of the relevant state. We have some of them also we've been analyzing them in Italy, because consider that in Europe, we have a slightly different situation because we have a directive. The directive forces us to implement the rules. And the directive says, the preamble number 24, that these rules have to be implemented in accordance with the OECD model rules, commentary, and administrative guidelines. And here we have the first issue. OECD released the document, the model rules, December 2021, commentary 2022, and guidance 2023, 2024. So far, we have 600 pages of rules. And the number of regulations, which are administrative guidance, are increasing. And the first issue that we are facing, but many jurisdictions are facing, how can the OECD, which is a body of unelected bureaucrats, which is highly skilled, highly capable, but OECD per se does not have any legal standing. That is why those rules must be transposed into the domestic legislation of the relevant state. But now we have a situation where the OECD realizes that some of the rules need some adjustments, some tweaks, some clarification, and this some amounted to 600 pages so far. So the first issue that we are facing all over the world is, which is the legal status of an administrative guidance, which is meant to be a clarification issued by the OECD. Under the Italian constitution, for example, they have no legal bearings. So what did we do in Italy, and other states also did? We said in the preamble of the Italian law that implemented the directive, the Pillar 2 directive, that these provisions must be interpreted in accordance with the model rules, OECD commentary, and guidelines. Now, this is perfectly fine as long as the commentary and the guidelines simply supplement the rules which are already provided in the directive or in the model global rules, in the OECD model rules. But de facto, they change it. They see in some aspects, they dramatically altered the content, the scope, and the direction of the rules. So we are now facing a situation where we'll be left to the constitutional experts, where we have a law within the Italian, in the Italian legal environment, which is a transpositional directive. The directive says something because the directive has been drafted in accordance with the 2021 model rules, which over time have changed. And so you have, by virtue of the mechanical, the operation of the global rules, member states have deviated from the text of the directive in order to comply with the OECD, which has no legal bearings, deviating from the European directive, which has legal bearings. So we are now living in a new world whereby the directive says something, the administrative guidance says something different, and the domestic law, which is the only relevant law for all entities located in Italy, says something different, meaning in accordance with OECD and in deviation from the language of the directive. And the European institutions, they realize that this discrepancy may prove to be difficult to be reconciled, and they issue a statement by the European Council of Minister of Finance and the European. I do not remember exactly those are the institutional bodies of the European Union. They issue a statement saying that the interpretation, the administrative guidance issued after the issuance of the directive must be used in interpreting the language of the directive. So they are trying basically to accommodate situations where to reconcile something which blatantly deviates from the law, because we are a rule of law, supposedly, jurisdiction, the European Union. The directive says something, the OECD says something different, and we, instead of following what the directive says, which is a legal instrument, binding legal instruments, we deviate from that legal instrument and we follow what the OECD says. And this may prove to be somehow challenging because it cannot be excluded that the court would say to the competent authority, what have you done? I mean, this is not something which is acceptable under the European, the Union law. You have to comply with the law. If the law is outdated, change the law. You can't change the law surreptitiously, I don't know how to say properly in English, sorry, by simply saying, well, these are interpretations of the law, where these interpretations are manifestly deviate from the language of the law. And the OECD itself, in some cases, acknowledges that they have changed the language, not the language, but how the directive works. how the OECD model rules work. So this is an issue which is not something that we are going to deal with any longer, which constitutional aspects are involved in all the jurisdictions. Because consider that this is an envisioned situation where one set of rules apply simultaneously in all the real life jurisdictions. So all the laws of all the states which have decided to apply the Pillar 2 have decided to apply the same rules and interpreted in the same way, consistent with the OECD interpretation. Now, consider, for example, in June 2024, the OECD issues 140 plus pages of interpretations. If the constitutional order of a country does not allow that country to rely directly on the interpretation put forward by the OECD, because those interpretations need somehow to be transposed into either primary law or secondary law regulations. Then you are, and then there is the taxpayer bill of rights, which requires that changing or amendments to the law can only apply as of the subsequent taxable year. While in other countries, like for example New Zealand, they made a direct reference to the OECD guidelines. They become model rules and commentary. They become de facto law of the land in New Zealand. So if the drafter have envisioned a situation where at the same time, all over the world, all the countries apply the same rules, and we have situations where from constitutional boundaries and limitation, a part of the rules cannot be applied if not starting from the next year, we have asymmetries in the application of the same rules. And this is not what the drafter has envisioned originally. So there is the risk that the slower wagon dictates the pace of the Pillar 2 train. Because if we accept the idea or stick to the idea that the same rules must be applied contextually in all the jurisdictions, the consequence is if for any reason, constitutional reason, a jurisdiction does not apply that rule in that year, all the other relevant jurisdictions should not apply that rule, because otherwise we have an asymmetrical application of this, which ultimately brings that the slowest wagon dictates the pace of the Pillar 2 train. So this is an issue which has not been sorted or addressed. Now let's go to because in the interest of time, to the rules or how they are devised, basically. Let's keep the structure of the Pillar 2. Ideally, as I said, the rules, the aim of the rule is to have all the jurisdictions to apply a 15% corporate income tax. How they do that? First of all, you consider a jurisdiction. For the sake of the illustration, let's consider that Hong Kong, Italy is one jurisdiction. Because if we go into the detail, we will find out that one legal jurisdiction may be divided up to 8 sub-jurisdictions. But we are going in detail here. Let's consider that all the entities located in Hong Kong form one jurisdiction. So I combine the taxes paid, due more than paid by those entities, over the globe income. So I do the ratio between adjusted corporate taxes and the globe income. The ratio gives me a certain percentage, which is basically, it's called effective tax rate. Conceptually, global rules are easy. So you could put the denominator, the adjusted corporate taxes, and the denominator, the global income, combine, and you end up with the ETR, effective tax rate. If the ETR is 13.5%, since the minimum rate has to be 15, you have a top-up tax rate, which is 1.5, which is the difference between 50% and 13.5. 1.5 times the global income of the jurisdiction, you find the amount of the top-up tax. which is the tax that has to be paid. Let's see where, in which jurisdiction, and by which entity, has to be paid so that the income of the Hong Kong jurisdiction reaches the 15% threshold. Now, the rules are extremely more complicated, but this is the backbone of the skeleton of the analysis. Combine all the taxes paid by the Hong Kong entities over all the income of the Hong Kong entities. If the rate is 15 or higher than 15, no top-up tax. If the rate is lower than 15, the top-up tax rate is the difference between 15 and the effective ETR times the globe income of Hong Kong. And that you have the amount. That is the top-up tax. The top-up tax now can be levied through two rules. Originally, there were only two rules: income inclusion rule and under tax payment, originally, subsequently become profit rule, which is a devilish mechanism, UTPR. We're going to look at and analyze it shortly. The entire Pillar 2 hinges on the role of the UPE, which is the ultimate parent entity. Not all the groups are in scope group, because only group which have reached the threshold of 750 million euros, converting into Hong Kong dollars, US dollar, Canadian dollar, American, Australian, so on and so forth, in the local currency. In two of the last 4 financial years. So in 2024, I am in the globe rules. I apply Pillar 2 if in either 23, 22, 21, or 20, I reach 700, the group reach 750 million euro for 2 years. They don't need to be one after the other. They could be scattered. If for some reason the financial year is shorter or longer, you have to adjust the relevant amount per 12 months. So if for some reason, to make it simple, the financial year is 6 months, you have to double the amount of the revenues in order to see whether you reach the threshold. So once you have computed the tax, the top-up tax, which is the amount that has to be paid with respect to the Hong Kong income in order for the Hong Kong income to be taxed at 15%, we have two rules which apply independently, alternatively, they do not apply. If the UPE is located in a Pillar 2 jurisdiction, then the UPE pays the top-up tax in proportion to the inclusion ratio. What is the inclusion ratio? It's the amount of income of the Hong Kong entity that belongs to the group. The group is a look at under the consolidated perspective. So a group is such if it provides for consolidated financial accounts. So if a group has controlled 70% of Hong Kong entities, and the Hong Kong top-up tax is $100, the UPE has to pay $70, which is the 70% of the $100. Why 70%? Because the group only controls 70%, is entitled to get dividends, to put it blatantly, to derive dividends only for the 70% of the dividends of the Hong Kong company, because 30% belongs to minority shareholders. So that is the rationale. It's a top-down approach. If the UPE is a Pillar 2 jurisdiction, then UPE pays the tax not to the Hong Kong tax authorities, but to the UPE competent tax authority. So assuming that we have an Italian UPE with a subsidiary in Hong Kong, the Hong Kong is taxed lower than 15%, and pay attention that the fact that the nominal rate in Hong Kong is 16.5 doesn't make any difference, because as a result of the application of the relevant computation rules, an ETR, a nominal rate of 16.5% may very well become far lower than 15 in terms of effective tax rate under the Pillar 2 lenses. I will give you an example later on. So I have the UP, which is in Italian. It's in Italy. Italy is a Pillar 2 jurisdiction, meaning that it applies Pillar 2. The UPE has 70% of the ownership as an ownership interest in the Italian entity for 70%. The top-up tax is 100. The UPE pays to the Italian tax authorities 100. What was the rationale of this mechanic? The rationale was we don't want the income whoever earned has to be subject to an effective taxation of at least 50%. The group is the relevant taxpayer. This is also a new somehow in the tax arena, where taxpayer are single legal entities or permanent established, not the group person. Here, we are in a new world. The group is a taxpayer. So for the group, paying 50% to the Hong Kong tax authorities or to the Italian tax authorities is absolutely irrelevant. 70 euros have to be 70 Hong Kong dollars, following our example, have to be paid. Whether the group pays those dollars to the Hong Kong tax authorities or to the Italian tax authority, it doesn't make any difference, because for the group is a cost of $70. Ultimately, by paying this $70, the Hong Kong income is taxed at 15%. Whether these taxes have been actually paid by the Hong Kong subsidiary or by the UPE, let's say not illegally, but on behalf of, because ultimately that income has been subject to tax at 50%. Now, this was the original rule. Over the course of the negotiations, remember, inclusive framework is represented. In the inclusive framework, more than 150 states are represented. So in the course of the negotiation, some of the developing states said, look, as a result of this mechanism, we are giving tax breaks to multinationals coming to operate in our country. And what we forfeit is ultimately picked up by the UPE tax authorities. We want to attract a factory. We give you 10 years tax holiday, 1 million income. We don't pay. We, developing country, we do not levy tax on that million income, but 15% of that tax is ultimately, in any case, paid, but paid to the tax authority or the ultimate parent entity. So ultimately, we, developing country, are funding your tax revenues. That's the devilish mechanism. So we want to have a tax that kicks in before, and this tax is a domestic top-up tax. A domestic top-up tax is any tax which somehow resembles the Pillar 2 top-up tax, meaning you compute, being a top-up tax, it's a tax that only applies up to the 15%. While there may be other minimum tax like the US one, the AMT, which applies with its rate, its computation rules, but doesn't change the amount depending on the amount of the ordinary tax. While the top-up tax, if the ordinary tax is 0, top-up tax expands. If the ordinary tax is 15, top-up tax will tend to become to 0. So that is a kind of top-up tax. It's a tax whose amount ranges depending on the average of depending on the effective tax rate of the other income taxes. So the OECD said, well, we allow the top-up tax of the source country. Let's use this jargon, which is quite, the international tax people are quite familiar, resident state and source state. It does exactly work in this way, in the same way as it works on the tax treaty, but just to give you an idea, the developing country, the so-called developing country, because we can have, as the US proved to be, tax haven also inside the United States because of some tax credit that were provided by, especially by the Inflation Reduction Act, which brought the ETR far lower than 15%. So the OECD said, okay, as long as you source state develop a tax, which is a top-up tax, which is in compliance, which follows, i.e., it is in compliance with the global rules, your tax comes first. So going back to the previous example, the country which gave up taxing right in order to induce foreign direct investment now says, dear foreign investor, either you pay 15 here or you pay 15 in your home state. So please pay 15 here. And the 15 paid here is computed, is deducted from the 15 year that you should pay in your home state, which ultimately means the home state doesn't get a euro. This is the design, okay? But this holds true as long as the domestic top-up tax is a qualified domestic top-up tax, QDMT. What the Q stands for? The Q stands for, certifies that a top-up tax has been designed in accordance with and strict adherence with the global rules, the OECD model rules. Because the OECD says, okay, as long as the QD entity bring the same result that the IRR would have brought in, then we give you a credit for that tax, because it's a tax which has been built along the same line, design line. So it's basically the same tax, has different name, is levied in the source jurisdiction and not in the resident jurisdiction, but the tax is the same. It's a top-up tax, so the amount changes year per year at the level of the jurisdiction, not at the level of a single legal entity. And so as long as you, dear state, design your QDMTT, so your DMTT, domestic minimum top-up tax, along the lines of the global rules, this becomes a QD entity. If it's a QD entity, 15 you pay in the source state, 15 you should have paid under the IRR in the resident state. In the resident state, you deduct from the 15 paid in the source state. So ultimately, you only pay tax, the group only pay taxes in the source, which is, if you think, the objective of the global rules has been reached. All over the world, taxation is levied on corporate tax, on corporate income, at 15%. Because if there is a jurisdiction which does not apply 15%, applies 13%, 2% is paid at the level of the UPE. Now, that jurisdiction can insert a QD entity which sucks up the 2%. So you have ordinary corporate income tax 13%, qualified domestic top-up tax to 2%, total 15%, no taxation at the level of the US system. The mechanism works perfectly? No, it does not work perfectly. And they needed to insert a UTPR. Why? Consider this example. I have a European company, UPE, let's make it very simple. A European company with a Hong Kong subsidiary and let's say Italian UP, Hong Kong subsidiary, and the French subsidiary. And then consider a US company with a Hong Kong company and a French subsidiary. So the same fact pattern, what changes is the location of the UPE. Up to now, US says we do not apply Pillar 2, which means that the low tax income of Hong Kong is not taxed in Hong Kong, is not taxed in US. So the US group, which has the same operation as the European group, is better off because it does not pay income tax in Hong Kong. So the group, same amount of income, same jurisdiction, pays less taxes overall than European group. This put the European group at disadvantage vis-a-vis the US group. So they come up with the devilish mechanism, which is a UTPR, which may prove to be unconstitutional in many countries, and time will tell. What the UTPR says, so dear Pillar 2 jurisdiction, in this case, in the previous case, Italy and France. In the second case, we have US group, US parent entity, Hong Kong, and France. The UTPR says, dear Pillar 2 country, France, you have to pay, you have to levy to the French entity the top-up tax which should have been levied by US had it introduced the Pillar 2. And if in its turn US is a low tax jurisdiction, the top-up tax that should have been levied by US had the US introduce a QDMTT, which basically means that the two different groups pay the same amount of taxes. Now, on paper, it works perfect. Real life. Let's assume that I have a US company with some billions of euros of income, which by virtue of the Inflation Reduction Act tax credit has an effective tax rate computed under the global rules of 10%. 1 billion euro dollars, 10% effective tax rate, top-up tax rate 5%, 5% of 1 billion should be 50 million, right? Plus the under tax income on Hong Kong, let's say 1 million. So 51 million must be paid under the UTPR rule by the French company. Now, first issue, assume that the French company doesn't have that income. Can you possibly pay a tax of 51 million euro, which is higher than your income, or even higher than your turnover? Well, I mean, the ability to pay principle. We have in our constitution the ability to pay principle. The ability to pay principle means that you pay taxes, whatever is the rate, up to your income. You can't pay 51 million of taxes out of 30 million of income. That's the expropriation. So we have constitutional issues all over the globe with this UTPR. The UTPR has not been applied yet. It will come into force in 2025. So there has been a leeway of 1 year for the application of UTPR. But the UTPR has been devised because otherwise, only the Pillar 2 jurisdiction would have levied Pillar 2 tax. And if you consider that neither China, nor India, nor US has applied Pillar 2 so far, or Russia, all the subsidiaries of UPR or UPE located in one of these 4 jurisdictions, located in jurisdiction other than Pillar 2 jurisdiction, they would never been taxed at 5%, at 15%. So they mean the OECD, they had to come up with a brilliant idea, say, well, you know what? We don't care whether the US doesn't apply, whether the UPE doesn't apply, whether Hong Kong doesn't apply, because we tax all the income full force in the hands of the Pillar 2 jurisdictions entity. Now, if there are 10 entities, not only the French entity, the 51 million are allocated through apportionment keys, assets, and employment all over the Pillar 2 entities. But the concept is the group has to bear the 15% tax cost, whether in a Pillar 2 jurisdiction by virtue of the QD entity or the IRR, or if there are non-Pillar 2 jurisdictions, with respect to the non-Pillar 2 jurisdiction income, taxes have to be paid in Pillar 2 jurisdiction, which is a fantabulous fairy tale world. Because then you go to the real life, and what happens, and it does happen, if a group says to the French company, we don't give you the data. Everything has to be computed in a very granular way with respect to each and every constituent entity, which is subsidiary and permanent establishment. In our example, in US and in Hong Kong, if the French company, which is not a UP, so it doesn't have the control over the other group companies, doesn't have the data, how can it possibly pay taxes on something that it does not have the data? And how the tax authority can perform an audit if it doesn't have the data? Because the data have not been surrendered. But if I'm not a Pillar 2 jurisdiction, if US, for example, is not a Pillar 2 jurisdiction, it doesn't have laws that force the US to UPE to surrender the data. So everything works in theory. We'll see how in real life it will play out. Obviously, multinational enterprises do not pay these tricks that, okay, since my French subsidiary is obliged to do something, and in order to comply with such obligation, needs to receive data from other jurisdiction which do not comply with Pillar 2, we disregard the French law and do not provide the data. De facto, there will be a transfer of data. The point is the quality of the data and the ability of the French tax authority, in our example, to audit the data of the US company, the data of the Hong Kong company. Because the ETR is mainly computed by making reference to the accounting data. If I look at the consolidated financial statement of the balance sheet, I have only the global view, but I'm not able to split the global view in the relevant jurisdiction. So if I'm the French tax authority, I may retrieve the consolidated financial statement, but I cannot deconsolidate the relevant jurisdiction in order to compute the ETR, assuming that the thousands of data needed are available. Consider that to compute the ETR, we made a rough estimate. You need more than 200 data points per company. It's not, because so far we said covered taxes numerator, global income denominator, easy. To compute the covered taxes, to compute the global income, you need 200 plus data points per entity. So if in a jurisdiction you have 15, 20 entities, you need thousands and thousands of data points, which are not available in the consolidated financial statement. They are not even available now in the groups. You have to extract those data from the IT system merely for the purposes of Pillar 2. So if a jurisdiction doesn't want to comply, if a group doesn't want to comply, the UTPR is there, but de facto may face difficulties in being applied because I'm the French company, going back to my example, I have received not enough data from my UPE and I cannot pay the tax, compute and pay the tax. And if I cannot do it, not even the French tax authority can do it. So the law is there, the rule is there, the application of the rule, the enforcement of the rule is difficult. For example, under the Italian Constitution, you cannot charge someone for a conduct which is not in line with law if he didn't have the way to comply. I mean, you can charge someone for willful misconduct, for gross negligence, but if I'm required to pay a tax on the basis of data that I do not have, that I cannot retrieve, that I asked my parent company to give me, it didn't give me the data, how can I possibly be considered liable for not having computed and paid taxes if I have not been given the data to compute those taxes? Because those are not the data of my company. Those are the data of my sister cousin, which is perhaps on the other side of the ocean, which is a subsidiary of a subsidiary of a subsidiary of a subsidiary of the UPE. So it is an issue. In theory, everything works because we are in the fairy tale world, one jurisdiction, one set of rules. When you translate the theory, which is an extremely fascinating subject matter, into the real life, you have problems. Now, I simply highlighted some of the problems that we have been facing so far or came across so far, and why in implementing the rules in the relevant jurisdiction and thinking how to implement other rules, because UTPR has not been enforced. It's not enforceable until next year, but we already figure out how can I possibly pay taxes for with respect to my Papua New Guinea, which under the Italian perspective is a far away subsidiary, which is not my subsidiary, is a subsidiary of my UPE, with which I have no connection whatsoever. But a similar example, I have it in Italy with a real life case of an Italian group listed company of a non-EU, of non-Pillar 2 UPE, Pillar 2 jurisdiction UPE. That UPE in Italy has 3 subgroups for hundreds of different companies. One of the 3 subgroups is listed in the Italian Stock Exchange. So under the QD the data of this company must be aggregated with the data of the other 2 subgroups. But the listed company have no clue whatsoever which are the data of the sister company, because those data are reported to the UPE, not to the sister. So the point is, how can I? Stefano is the Italian entity of the UPE, and Professor Cullen is the other Italian entity of the UPE. He doesn't transmit the data to me. He transmits the data only to the UPE. The UPE does not transmit his data to me, but I'm liable for him vis-a-vis the Italian tax authority if he doesn't pay taxes. So if he has 100 euro of global income and 0 taxes, I have 100 euro of global income and I pay 15 taxes, I'm okay. But because of him, in aggregate, we paid 15, the one I paid, and we had 200. And the Italian tax authority said, sorry, Stefano, you are jointly severally liable. You pay the tax. He said, but I have no fault. His fault. The Italian tax authority said, I don't care. You are one group. I come after each of you, and then you pay me, and then you adjust internally. The point is, I have no data. How can I possibly compute my liability? Because my liability is inherently linked with his data. If I don't have his data, it's difficult or impossible for me to compute my liability. The same applies for the Italian tax authorities, obviously. So the entire system is premised on the fact that all the relevant jurisdictions will apply Pillar 2, will comply with the Pillar 2 rules, will force the entities to surrender the data, because there will be, and I stop myself, there will be one global information return which aggregates. Assume that a company has 40 jurisdictions, and in total 1,000, a group has 1,000 companies. 1,000 companies, 200 data per company, 200,000 data. They are all gathered in one global information return, subdivided per jurisdiction. This information return is a surrender by the Italian UPE to the Italian tax authority, by the Italian tax authority to the OECD. The OECD disaggregates the data per jurisdiction and transmit the data to the relevant jurisdiction. And then I have other layers of complexity, because so far we have been analyzing the level of all this data must be computed under the financial accounts of the UPE. But then the OECD allows deviations where you compute the liquidity entity on the basis of the local accounting standard, which may have different value as opposed to the carrying value of an asset under the local accounting standard may be different than the carrying value of the same assets under the consolidated accounting standard. The different carrying value triggers different DTA, different DTL, different numerator, different rate, different top-up tax. So it's a fairly complex, and in the interest of time, I stop here, but the subject matter is extremely fascinating, highly complex. So far has become true in Europe, Canada, Australia, Japan, Korea. Next year, we roll out in Singapore and other minor jurisdictions with massive foreign presence. They are rolling out QD entity, which is the ultimate goal. The purpose of this nightmare is not to pay €1 of taxes at the UPE level. Because if any of the UPE pays €1 of tax, it means that all over the world, there is at least 15% taxation on the corporate income, which is the ultimate goal of the OECD. So they created a monster to show that the ultimate goal is to show that not even €1 has to be paid in the UPE jurisdiction. At that point in time, the goal is reached. Because it means that in Hong Kong, they tax 15. In Bahamas, they tax 15. In Vietnam, they tax 15. And that is the ultimate goal of the OECD. So they created a devilish machine with enormous computation to prove that I don't have to pay, because I've already paid in the local jurisdiction. So that is the ultimate goal of the OECD. To reach that goal, they created this fairly complex set of rules, which are in the process of being enacted and amended, interpreted, and restated by the OECD twice a year on average. Thank you for your time and the patience.
Well, thank you. Really fascinating presentation. Thank you, everybody, for participating and listening. And we'll, as I mentioned before, we'll have the PowerPoint slides up, the recording, and we'll also mention your book on the website.
Thank you again, Hong Kong University, for having me.
A great pleasure.
Thank you. Bye-bye.